This case moves fast, but don't let that fool you. What you're about to watch is a life-changing courtroom moment where one decision locks in years behind bars. We've got Adrian Harper standing in front of the judge, facing serious felony charges tied to controlled substances. But here's the twist: this isn't a full trial. This is a plea deal. And in cases like this, everything comes down to one question: does the defendant truly understand what they're giving up? Because once this process starts, there's no easy way back. Rights get waived, appeals disappear, and sentences become final fast. So pay close attention, because what looks routine is actually high-stakes legal pressure unfolding in real time.
Who's here on Adrian Harper? All right, the court is calling 2025 CR 012745 State versus Adrian Harper. Can I have parties announce?
State.
And are you Mr. Harper? Counsel, have you received all discovery? Did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Harper, did you review the true bill of indictment with your attorney? Did you understand it? All right, do you need more time?
No.
All right, did you review the indictment? Counsel, do you waive the reading? State, are you proceeding on the indictment as presented?
Judge, we're waiving the punishment enhancement and also proceeding on the lesser included offense of attempted manufacturing.
Any objection? All right, did you review the court admonishments with your attorney? Did you understand it? And did you sign it in all the appropriate places? All right, the state is proceeding on the lesser included offense of attempted manufacturing and delivery of a controlled substance, penalty group 1, 4 to 200 grams.
Right here is where the weight of the situation becomes crystal clear. The judge breaks down the charge: attempted manufacturing or delivery of a controlled substance, and the possible punishment, up to 20 years. That's not small. But notice something important. The state is going with a lesser included offense. That usually means the defendant is getting a deal to avoid something worse. Still, even with that deal, the judge makes it very clear she does not have to follow the agreement. So think about it. Would you take a guaranteed 4 years, or risk going to trial and possibly facing much more? Drop your answer in the comments. This is the kind of decision that changes everything.
That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses? Okay, everybody stop whispering. The court reporter can't hear, I can barely hear. Thank you. Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Okay. Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense. Punishment is to be assessed at 4 years in the prison. This is run concurrent with 2025 CC 010584, DC 2024 CR 1108, and taking consideration 2026 PF 15451. Did you understand that to be the plea?
Yes, ma'am.
Defense? State?
It is, Judge.
Did you review the waiver of appeal paragraph with your attorney and did you understand it and sign it in both places?
This is one of the most critical moments in the entire process, and most people don't even realize it. The judge is confirming that the defendant is waiving his right to appeal. That means once this plea is accepted, there's almost no going back. No retrying the case, no challenging the outcome, unless something very specific and rare applies. On top of that, he's also giving up his right to a jury trial, the right to confront witnesses, and the right to remain silent. So ask yourself honestly, do you think defendants fully understand how final this decision is in moments like this? Or are they just trying to get it over with?
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions? Then to the lesser included offense, how do you plead? State any evidence.
Judge, you're up to exhibit number 1, including all attachments.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yeah.
Anything you wish to say on behalf of your client? Then the court will sentence you to 4 years in the prison, give you credit for any time served. This will run concurrent with 2025 CC 010584, DC 2024 CR 1108, taking consideration 2026 PF 15451. There's to be no residing in households with minors and no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, next we're proceeding in 2024 CR 1108. Did you review the motion to enter adjudication of guilt and revoke community supervision and First Amendment motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Adrian Harper who was placed on deferred adjudication in 2024 CR 1108 for the offense of possession of marijuana 4 ounces to 5 pounds on February 22nd, 2024 for a period of 3 years? Is that you?
I am.
State.
Judge will be proceeding on violation of condition number 1, specifically that on or about the first day of July 2024 in Berry County, Texas, the defendant Adrian Jelani Harper committed the offense of Vandal controlled substance in violation of condition number 1.
All right, how do you plead to manufacturing delivery of a controlled substance in violation of condition number 1?
No contest.
That's either true or not true.
True.
State.
Judge will waive the remaining allegations.
Any objections to the waivers? Did you understand by pleading true to violations of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 1?
No.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Judge, we ask that this run concurrently with the previous plea. previously.
And what time are you all asking for?
4 years, revoke 4 years.
We're asking to revoke, Judge, but I believe that it's state jail, so we'd be asking for 2 years state jail.
Are you asking the court to follow that agreement?
I'm confused on that part.
They're asking that you no longer be on probation, that you be revoked, and that you be sentenced to 2 years in the state jail facility.
We run concurrent 4 years, correct?
Yes. And so are you asking the court to follow that?
Yes, ma'am.
Are you waiving your right to appeal?
Aye.
All right, the court will find you guilty, revoke, sentence you to 2 years in the state jail facility, give you credit for any time served. This will run concurrent with 2025 CR 012-745. There's to be no residing in households with minors and no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney and that cause number? Did you understand it and sign it?
Yes.
All right, because you entered into a plea bargain agreement and I followed your plea bargain agreement, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. Make better choices, all right? Okay, bye-bye.
And just like that, it's over. Adrian Harper is sentenced to 4 years in prison, with an additional 2-year state jail sentence tied to a probation violation, all running concurrently. The judge accepts the plea, enforces the deal, and locks in the outcome. No trial. No appeal. Final. This case is a perfect example of how the justice system often works behind the scenes, not dramatic jury trials, but fast, procedural decisions where defendants weigh risk versus certainty. But here's the bigger question. Was this a fair outcome, or just the safest option for the defendant under pressure? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.